The Knoxville Bar. I'm here on behalf of the defendant appellant Joshua Sullivan. If I could reserve 5 minutes of my time for rebuttal. We have raised a number of claims in our brief. I'd like to talk about two sets of those claims today. First, the excited utterance claims, and then the what I'm calling the assertion of constitutional rights claims. This was an allegation that there was an alleged a rape that happened in the early morning hours. Then roughly 20 hours later, the complainant disclosed this allegation first through a video chat app to her friend and then to her sister. The complainant was 11 years old at the time this happened. Both that recounting of the allegation to the friend and the recounting to the sister were introduced into evidence at trial as excited utterances. If I could begin just a little, to step back a little bit to what I understand the idea of excited utterances to be. And to be honest, this is one of the things of the common law that I have no idea whether actually matches up with modern science. But I think the idea is there are some things that happen to us that are such a shock to the system that we essentially can't lie when we're talking about them. We are, our whatever part of our brain that has the ability to fabricate, that gets shut down. And excited utterances are exceptions to the hearsay rule because there is this common law presumption that what is coming out of our mouths at that time is at least much more likely to be true than if we had the ability to fabricate something. And I think that is consistent with how this court and the Tennessee Supreme Court have discussed the excited utterance exception. We have had, I think the parties are largely in agreement on the set of cases that define the different elements of excited utterances. In particular, State versus Smith, talking about what it calls the ultimate test. And the ultimate test, it says, involves whether the parties are still laboring under the excitement and strain of the circumstances, and at a time so near it as to preclude the idea of deliberation and fabrication. So what I think that concept eliminates, both on the theoretical level and also this language of Smith saying still laboring, it eliminates a situation where there is a startling event, then there is a period of calm in which someone could invent, fabricate, otherwise have normal operation of their mental faculties, and then they work themselves back into a state of excitement. Because if we don't have what one of the federal courts called a continuous period of stress, then we can no longer use this theory of mind to eliminate any possibility of fabrication. And if we can't do that, then we are not in the excited utterances hearsay exception, and because this is a child, we're not allowed to include fresh complaint. Here, I think both the state in proposing this evidence and the trial court in accepting this evidence simply misunderstood the doctrine. They believed that because it was a starting allegation, that there was an excitement on the front end, and because when the complainant was reciting this allegation, she was obviously emotionally distraught, that those two facts were enough to establish excited utterances. The state, in its proffer for both of these witnesses, essentially presented no evidence whatsoever as to what had happened in that 20-hour time period. There was some testimony from the complainant. She didn't really remember if she'd seen the defendant, probably saw him around. It was like a normal day. So the state didn't even try to establish that this stress, excitement, upset lasted during the course of the day, because the state believed that was not part of its burden, and the trial court's reasoning was the same.
Mr. Harwell, could you have a re-excited utterance under Tennessee law?
Yes. And there's
why is this not a re-excited utterance? So if the startling event is the event and then perhaps maybe talking about the event then with a friend initially, why could that not be a re-excited utterance?
So there's certainly a line of cases about a subsequent event, but that subsequent event has to be a startling event. So I won't get the cases' names right. There's a case about a rape where the complainant then discovers she's in the bathroom and is in pain and is bleeding, and immediately calls out about what has happened to her. There was a case cited in one of the treatises, a kidnapping and a beating, and the victim's in the hospital for a week and comes home from the hospital and then sees a picture of the defendant and says, "That's the guy." And it's the seeing the picture that is the startling event.
Hardly a startling event in terms of, oh my gosh, that's such a shock perhaps. If seeing a picture could qualify as a re-startling event, couldn't a friend approaching to say, "Hey, what happened to you?" also qualify then as a re-startling event?
I would say two things. One, the state never even claimed that there was another startling event in the trial court. And two, if we start to say that just thinking about the event rather than suddenly being confronted by it, suddenly being confronted by a physical manifestation, if we just say just thinking about it, then we can have a sort of perpetual excited utterances. That every single time she tells the story, if she has an emotional reaction, then are we saying that's an excited utterance because she's upset again 6 months later? So I think that case law on subsequent startling events is limited to a discrete new event that itself is startling rather than just remembering back to the prior startling.
So help me with this. Let's say that I were to agree with your position on the evidence law. Help me with understanding here about the effect of that on the trial. So my understanding is that the substance of the exact same statement came in at trial without objection when the victim was permitted to testify that she told her mother what had happened, and also when she told hospital staff. If the substance of the statement is out in other ways without objection and therefore able to be considered by the jury for its evidentiary worth, under this circumstance, do you win the battle but lose the war?
And I understand that's certainly what the state is contending.
So help me with your position on that, please.
And I would say a few things. One, this is something the state sought to bring out, and these are the first two supposed recitations of what happened. So if thinking of it in terms of a fresh complaint, these are the freshest of the complaints. The state put on both of those witnesses to testify to that. They called Sophie, they called Aya, the sister, essentially for that purpose. The state certainly, in closing argument, cited the fact that she had told the story again and again and again as a reason to credit her. The story to the mother came in, at least on the theory that it was going to explain what the mother's reaction was in terms of setting the whole train of investigation into process. And then, as you say, that it also came in terms of what she told the hospital, although what she told the hospital was actually significantly different than what she testified to at trial, in the sense that in telling the hospital what had happened, she did not make any allegation of anal penetration or attempted penetration. And according to the hospital records, she gave an indication of ejaculation. And so that's why we had so much efforts to find sperm or semen, which didn't turn up anything. And then by the time she gets to trial, she doesn't mention ejaculation. So we have possibly four times she told the story, two of which shouldn't have come in, one of which was inconsistent in significant ways with her trial testimony. And so I don't believe that that was harmless. in the way that the state presented this case. Now, the state could have not called those witnesses, could have not tried to use that evidence in any way, and presented the case differently, but having made that decision, I think it's hard to call that harmless. If I could move to what I call the sort of constitutional assertion issues, this arose in a weird factual way in that as law enforcement came to the house, took Mr. Sullivan's son into custody, or pulled guns on him, put handcuffs on him, put him on the ground. While that is happening, the defendant called his son. Officers answered and had a FaceTime conversation with Mr. Sullivan, who was trying to figure out what was going on and then trying to check on his son. During the course of that conversation, they say they're going to go in the house. Mr. Sullivan says, you need a warrant. And they ask him where he is. He says, I go to my lawyer's office. Both of those things were raised prior to trial by defense counsel, saying that this shouldn't come in, was argued repeatedly, but the trial judge ruled that both of those things could come in. And they were particularly the you need a warrant comment. The state went to some links to highlight that. And I set out in the brief, they played this body cam in which you can hear these statements. They played the bit about you need a warrant. They stopped the tape. They said, what did you hear, to the testifying officer who was publishing this. He said, I heard him say, you need a warrant. They rewound it. They played it again. They ask again, what did you hear? You need a warrant. They get to closing argument. They talk again about how the defendant said, you need a warrant. So, I think both of these are relatively straightforward constitutional violations. We have the right to decline to consent to searches of spaces that we have protected interest in. We have a right to consult with defense counsel. And the law is not merely that we have those rights, but also, and maybe even contrary to common sense, our exercise of those rights cannot be used, we can't be punished for exercising those rights. Our exercise of those rights, even if it might be common sense otherwise, can't be used as a fact to conclude that because we don't want someone to look in our protected space that we must have something bad in there, or because we're going to talk to a defense attorney, we must have some consciousness of guilt.
What do you make of the state's argument in their brief that the state wasn't eliciting this to show his consciousness of guilt? They were eliciting it because it was probative of flight, I believe, as I understood their argument in the brief. What do you make of that?
I don't understand how going to see your attorney can be probative of flight. If he said, I'm going to Mexico, that would be one thing. But he said he's going to see his attorney. So I don't see how that could be probative of flight. The state suggested in the trial court that they were actually introducing it because it wasn't true. But then they never proved up that it wasn't true. So what you had in the record was just this statement of, I'm on my way to my attorney's office. And again, this is not, I think I'd be in a much different place if this is something that sort of slipped through and no one really paid attention to it. This is something defense counsel raised, as I said, before trial, argued about it over and over again. And the prosecutor made a decision of, do I want to redact that 10 seconds of this, or do I want that in for some reason? And it came in, as I said, I think both of these are straightforward constitutional violations. Because of that, at the very least, they get the Chapman standard of review requiring reversal unless harmless beyond a reasonable doubt. So a better standard than we have just for the evidentiary issues.
So back to Judge Hickson's question. My understanding is that it was being argued that it was relevant to flight because of the time of day at which the statement was made. So it would be one thing, perhaps, if I was making the statement, I'm going to see my lawyer now, and it's during normal business hours. Here, as I understand it, the statement was made at 11 o'clock at night when no one would reasonably expect the lawyer's office to be open. And so in that case, without any reasonable explanation for that the state was arguing it must be that he's leaving because he wants to flee. So the help me understand the context of it and how the context of the statement being made shows clearly that it's irrelevant for flight purposes.
I think it's important to differentiate what the state was saying and arguing to the judge and what they presented to the jury, because that theory just didn't make its way to the jury. So yes, the state was saying it's implausible that he could be going to see his attorney at 11 o'clock at night, but it did, and therefore this is a sign of flight. But how's the jury supposed to know that? Right? Why is the jury not going to think he's going to see his attorney because he's guilty? So if the state has a limited way that it's trying to use this, it needs to make the evidence needs to make that clear to the jury instead of just putting it out there for the jury to be free to conclude only guilty people talk to defense attorneys.
You're getting into your rebuttal time.
Yes, and I'll reserve the rest of it for rebuttal. Thank you.
State.
Mr. Harwell is quite a bit taller than me. May it please the court, Courtney Orr, on behalf of the state of Tennessee, I will take the issues in the same order that defense counsel took them, starting first with the excited utterances. Simply put, the defendant's position that the laboring under the excitement of the events must be continuous from the initial exciting event to the statement is contrary to case law from this court and the Tennessee Supreme Court, and is contrary to the rule or to the language of Rule 803. Rule 803 states that a statement relating to a startling event or condition made while the declarant was under the stress caused by the event or condition is admissible. While under the stress, it does not say still. I understand that that appears in some other case law, but the Tennessee Supreme Court has made it clear that the length of time between the initial startling event and the declarant's ultimate excited utterance is but one consideration.
It's an important consideration, though, right?
It is an important consideration.
Okay, so, and you're not doing this, General, I know that, but sometimes I think that we have a tendency to minimize that factor, and in fact, that factor is one of the most important factors in the analysis, is it not? I mean, at some point, we all agree that the time has gone by so far that the processes for deliberation and reflection, in fact, have not been suspended. Right, so if a statement occurs a couple of minutes after a startling event, that's one thing. If it occurs years after the startling event, that's something else. And so the time factor is important here. Really what we need to be focused on is whether the statements themselves show spontaneity, right, in response to the startling event.
Generally speaking, yes, I believe your question has kind of two parts. First, as to the importance of the factor. It is an important factor, yes. The case law does not rank the factors.
It's not dispositive, that's true.
Right. As for the amount of time, yes, that is something to be considered. And here it is less than 24 hours. This rape occurred sometime after midnight. It's not clear what time. The victim was sitting on her bed as less than 24 hours later as the family was getting ready to go to sleep for the following evening. So this is a less than 24-hour time period. And the other factors listed to be considered indicate that the victim was under the stress of the event and that this showed that spontaneity that we require for an excited utterance.
That the process of deliberation and reflection have been suspended,
Yes.
such that then the statements can be considered reliable despite them being hearsay.
Yes, Your Honor.
What would you make of a circumstance where the victim is being asked questions? It's like, what happened? Tell me what happened. Would you say that the process of deliberation and reflection is suspended when you're answering questions? Because you're having to think about what the answer to the question is, right? Isn't that the very process of deliberation?
I believe that that would depend on the context in which the questions are being asked. And here, that context, and Ms. Russell does say, I had to ask the victim about this. But what led to Ms. Russell asking this is the victim called Ms. Russell. The victim, when Ms. Russell answered the phone, was very upset. She was crying, she was sobbing, which is not normal for the victim. Ms. Russell was like, this isn't normal for her. I couldn't understand what she was saying. And that's when Ms. Russell started asking, what's wrong? What happened? And it took a minute of Ms. Russell asking questions. And I defer to the record of this. I think she testified that the victim was not answering, but finally the victim said, Josh raped me. And at that point, Ms. Russell asked some clarifying questions. What do you mean? She testified, or excuse me, the victim said, he put it in me. And Ms. Russell said, you need to report this. So the context that we have here shows that this is not like a police investigation where they are pulled in and they are being continuously asked questions under a skilled investigator. This is an 11-year-old girl who has returned to the scene of where her de facto stepfather raped her less than 24 hours after that incident. She is upset and she calls her friend and eventually, within minutes, tells that friend, my stepfather raped me. So in this context, this does not show that questioning would suspend what we look for in terms of spontaneity.
I'd asked your friend on the other side about the impact of the similar statements coming in without objection. As I understood the argument, he was suggesting that those were different contexts being offered for different purposes, and so that the same information before the jury coming in for different purposes wouldn't render this error harmless. What's your response to that?
I respectfully disagree with defense counsel's characterization of the record here. These were not, especially Ms. Whitaker's statement, were not offered for different purposes. I want to take a moment just to clarify and say what the record says here. In the pretrial hearing, we were discussing the statements of Ms. Russell and the victim's sister. The court asked defense counsel, are you objecting to the statements from Ms. Whitaker? The defense counsel said, no, I believe those come in for a non-hearsay purpose. He made no other effort to ensure that Ms. Whitaker's testimony came in for a non-hearsay purpose. Ms. Whitaker's testimony was submitted for substantive evidence. The defendant asked for no limiting instruction. He asked that there's no indication that the court instructed the jury that this was to show the effect on Ms. Whitaker's actions or the effect on the listener. The victim's statements to Ms. Whitaker were admitted as substantive evidence, and they are substantially similar to what the victim said to Ms. Russell and Ms. Aldebert. Additionally, yes, there is a little bit of substantive difference in the statements to hospital staff in that the victim provided details. The victim provided details of how this rape occurred, but her statements that she was raped and that the defendant was the person who raped her remained consistent throughout that entire time. And that was the true issue here at trial. There was a little bit of dispute about the types of penetration. In fact, the jury found attempted rape on one because of disputed penetration, but the true dispute at this trial was the identity of the victim's rapist. And throughout every single disclosure, from Ms. Russell through the forensic interview, the victim identified the defendant as the person who raped her. And she specifically at trial disclaimed that Joshua Christopher was her attacker. So I understand the defendant's position, but, and this court has not reviewed the record before today, once you get into the record, you will see that yes, these two statements, had they been excluded, would reduce the proof by two statements. There is still overwhelming substantive proof that the victim identified the defendant as her rapist consistently from the time of the rape to the trial. And because of that, the defendant cannot show that introduction of the statements to Ms. Russell or Ms. Aldebert more likely than not affected the judgment of the jury. Unless there are further questions about the hearsay issue, I will turn to the statements captured on the body camera footage. Starting with the defendant's comments, you need a warrant. I'm sure this court noticed in my brief that I did not attempt to defend the admissibility of this statement. It is, I think, probably was an error for the state to introduce this statement. There is, quite frankly, not a lot of discussion about it in the record. The state simply said this is relevant to show he was destroying evidence. The court says, I think it came in, and that's all we have. I, like defense counsel, don't really see how that's anything other than an indication of guilt. However, this is
Do you
still-
agree? Do you agree we're under the Chapman standard?
I actually don't believe the case law is clear that this is a constitutional violation. Tennessee case law has not addressed this specific issue. There is a split of authority in the federal courts about how to treat this. Some federal courts do treat it as a constitutional violation and apply the Chapman standard. Other federal courts say this is just an evidentiary issue, and it's not admissible because it's simply irrelevant to anything that it could be. Since Tennessee courts have not clarified where Tennessee was standing on that, I can't agree that Chapman applies. But this court does not need to reach that issue in this case because we satisfy the Chapman standard. Looking at this record, it is clear that even if admission of this testimony was an error, and even if that error was of constitutional dimension, the defendant is still not entitled to a new trial because the evidence was harmless beyond a reasonable doubt. As I have stated earlier in the prior harmlessness, even if we remove the two statements made to Ms. Russell and Ms. Aldebet, there is still overwhelming proof that the defendant raped the victim and that he was the person who committed these offenses. He tried to pin this on his son, and the jury specifically said no. The son testified it was not me. The victim testified it was not me. And I would be remiss if I didn't point out that at the motion for new trial, the court observed, I believe that the defendant's strategy of trying to pin this on his son offended the jury more than any piece of evidence that came in. So while he put forth a vigorous defense, there is still overwhelming proof, including DNA that matched the defendant's YSTR profile inside the victim's vagina. And
You said earlier, though, that the main issue in this trial was identity.
yes.
Is it not at least possible that the jurors were sitting back there saying, well, we're trying to decide if it was him or his son? I'm going to say it's him because he's the one refusing consent to search his house, and he's the one looking for a lawyer immediately after this happened. Wouldn't that be viewed as incriminating evidence in the eyes of the jury?
I believe that there is a slight possibility that that happened, but again, that we're looking at beyond a reasonable doubt. So beyond, I believe the instructions say that reasonable doubt is not beyond all doubt. Here, when you look at the record,
Is that reasonable, that a juror would think that when presented with that proof erroneously?
I don't believe the question is whether it's reasonable that a jury would think that. I think that the question for harmless beyond a reasonable doubt is when looking at this record and looking at the proof presented, whether a juror's thought about the defendant's assertion of a right, or his right to a warrant, would tip their judgment. And here, when you look at the record, there's simply no reasonable conclusion to that because the proof so overwhelmingly identified the defendant as the offender in this case.
General Orr, you were very kind to note the issues with the statement regarding the warrant. What about counsel's? What about the statement regarding I'm going to see my lawyer? On the merits, not on the harmless error aspect to it, but on the merits.
Yes, this one was properly admitted because, and I do want to point out that it is a little muddled in the briefing. The statement was not, I'm going to consult with my lawyer. The statement was, I'm on my way to my lawyer's office.
Right.
This was made at 11 p.m. Yes, the state did not, in the moment this was introduced, set forth its entire theory for the jury as why this would indicate flight. But when viewed in the context of all of the state, or all of the evidence produced and introduced by the state, this statement was circumstantial evidence that the defendant was fleeing and trying to mislead police about where he was. He told the police at 11 p.m., I'm on my way to my lawyer's office. Other proof showed that at that time, instead, the defendant, who had left in Ms. Whitaker's car, was driving away from the scene after the police had followed him, abandoned the car in an unfamiliar part of the neighborhood in front of an unfamiliar house, called his girlfriend and had his girlfriend come pick him up, and then, from the defendant's own testimony, said he was trying to contact his lawyer from the girlfriend's house, but there's no other indication that was true. And then he remained at his girlfriend's house for days after that time. He was communicating with Joshua Christopher, asking, is anybody home? I don't want to come up and somebody jump up on me. He's trying to avoid discovery. Viewed in the context of this entire record, That, which is what the state was doing when they tried to present this evidence. The statement, "I'm on my way to my lawyer's office," made at 11 p.m., is circumstantial evidence, and a juror could reasonably conclude that the defendant was not on his way to his lawyer's office. He was trying to avoid police discovery. And because that is relevant to something other than his guilt or his identity for this offenses, it is relevant to show that he is not going there, then it was properly admitted, and it is not a constitutional violation. Even if this court were to disagree with me, it is still harmless beyond a reasonable doubt for all of the reasons that we discussed with the warrant comment.
Let me, defense is saying that when this evidence was put out about going to my lawyer's office, that it was just left there hanging. Was this argument, I haven't read the closing arguments yet, was this argument made to the jury that this showed proof of that he was lying and was flight, or was it just left out there, which the defense is trying to say is just, it was left for the jury's imagination that, well, you know, he obviously is guilty, why else would he be going to his lawyer? Or did they point out the significance of the time and that this was really, you know, could be interpreted as a ruse to hide from the police?
I want to start with the jury argument portion of your question first. The court instructed the state not to argue it in closing, and they did not. I believe that was the lawyer's statement. I will defer to the record on that, but it was not specifically highlighted in closing to my memory. The state did argue that there was this general plan of a flight. And in terms of it just hanging out there, this statement came in, I think it's around the middle of the body cam footage. So it's in the jury is watching this body cam footage, and it is rather dramatic body camera footage. So it was not, I don't want to say that it doesn't matter that they didn't follow up on this, but this was not the type of situation where the state asked the officer about it and they answered and then they just left it there. It came out within the context of which it was said and within a lot of other evidence that was being presented to the jury simultaneously.
And then why did the judge tell him not to argue it?
I believe the judge was concerned that we do not want to go, it found this is relevant to flight, we are going to allow it in for flight alone, but we do not want to endanger crossing the line into suggesting that he was going to consult with an attorney in violation of his constitutional rights.
Was there a limiting instruction given?
Not to my memory, no. But just to, I'm sure this court will have their questions, but just to conclude on this issue, this is not the same as other cases in which the state has introduced evidence about trying to consult or hire a lawyer for the purpose of showing that consultation with a lawyer was evidence of guilt. In those cases, specifically the ones cited in my brief, the state was saying, you were charged with a crime and then you consulted with 1, 2, 3, 4, 5, 6 lawyers. Why are you consulting with all of these lawyers if you're not guilty? That is not what happened here. The state introduced one statement made from the defendant to the police in his attempt to avoid police discovery to show that the defendant was not cooperating with police, as he suggested in his case in chief, to show that he was trying to flee from discovery.
General, what about in the appellant didn't raise the issue here for argument today, although it's very well presented in the briefs on both sides. What about the 609 issue with respect to the 2005 convictions? Are those convictions, both for possession of methamphetamine and possession of the firearm, are those probative of credibility outside of there being felonies?
The court found that they were probative of credibility because of the fact that he had multiple felony convictions for drug offenses, which this court has said that multiple convictions can be probative of credibility more than just one conviction. And the court's specific finding was these are probative of credibility because it shows that this is more than just one incidence of one marijuana charge, that he has multiple prior felony convictions.
Well, generally speaking, though, a drug possession offense is not particularly probative of credibility. Would you agree with that? I mean, that's what Waller says, right?
Yes, that is what Waller says.
So if, and this isn't exactly, I think, what the state's arguing, but if you have zero probative value with respect to one offense, 0 probative value with respect to 2 offenses, and 0 probative value with respect to 3, you're still at 0 probative value. So how does the fact that multiple offenses that don't have probative value individually add up to something where it's all of a sudden now admissible under 609?
I disagree with with the idea that Waller saying 1, 2, 3 of 0 probative value would equal.
I'm not saying that,
Okay.
yes, I was going back to the trial court's rationale as you've identified it, that it might not be probative with one conviction, but maybe probative of credibility with respect to several convictions. And my thought was simply that 0 plus 0 still adds up to 0.
Respectfully, Waller says that 0 plus 0 adds up to something.
It can add up to 1.
Waller says multiple prior convictions are more probative than a single conviction, and that is what the court's ruling was. So that does follow the Waller precedent.
So how about this? What was the rationale of the trial court, though, with respect to the staleness of the convictions?
The trial court did find that they were outside the 10 years, but that because there were multiple convictions, that did go to probativeness under the Waller standard. I do not remember the ages of the convictions in Waller, so I don't remember if that is exactly probative, but this court has repeatedly said that, and I realize I'm out of time, but okay. This court has repeatedly said that even the convictions that are outside of the 10 years, they can be admissible if they are probative of credibility or probative for what they are being offered for. Here, the court did find that. And if their probative value is not outweighed by the danger of unfair prejudice. And here, that was not, there was no danger of unfair prejudice here because the defendant is not being, these prior convictions are not similar to the charges that he is on trial for. Here, they are probative of his credibility, as Waller states. And the trial court applied the proper legal analysis test and did not abuse its discretion when it entered those convictions. Thank you, and we ask that you affirm the judgment of the trial court.
With the court's indulgence, I'd like to offer an analogy, and I recognize this is not a closing argument, but it's something I've been thinking about. You know, certain cities where there's a lot of tourists, and then there'll be the guy standing out there with like the 3 cups, and the tourists see him put something under the cup, one of the cups, and they say, you know, if you follow where the cup is and you pick the right cup, you win, you know, $20, and he shuffles it around, and regardless of where the tourist points, when you pick that cup, there's nothing in it. And that's the feeling that I have had in addressing the harmless error situation here. We had, as to the excited utterances, the state fought tooth and nail to be able to present the testimony of Sophie and Aya. The state called these 2 witnesses to the stand. The state presented this testimony. It talked about it in closing argument. It cited the fact that this is something that the complainant said over and over and over again as a reason to believe her. It was a huge part of the state's case that she had told her best friend and then told her sister about it. And now when we point out that there's a legal problem, oh, that didn't matter. And again, with the issue particularly about the warrant, as I said, and I think this matters, defense counsel pointed out prior to trial, there's a constitutional problem. And they argued over and over again, and the prosecutor wanted it in. And the prosecutor played that video and asked the officer about it. And then the prosecutor played that video again and asked the officer about it again. And then closing argument, the prosecutor talked about it again. So there was a decision made by the state of Tennessee. There's something important about this because we're going to fight to get it in. And now on appeal, oh, it doesn't matter. And I don't think, I just caution the court to approach the issue of harmless error by looking at the entire record, and particularly by looking at the way the case was tried, because this stuff was relied upon heavily, and to imagine that just because there was some other evidence that none of this made any difference, I think is not accurate. I would commend, you know, this is a case, there was testimony from a complainant, there was some DNA, there was a relatively prompt, within a day, complaint. And on its face, I could see, if you're just thinking about it that way, there's an identification and a DNA slam dunk case. I would come into this court, the closing argument by defense counsel, because I think he did a really good job in summarizing how almost all of the evidence, other than the complainant's testimony and the son's testimony, almost all of the evidence was consistent with the defense theory of what had happened. And obviously, and this is, I'm not insulting the court by reminding it, defense wasn't having to prove that was really it. As Judge Hickson, as you were pointing out, all the defense needed to do was establish a reasonable doubt that have a jury have a reasonable doubt that that could have been what happened. Two other brief comments to go back to the excited utterance issue. The opposing counsel mentioned that the word still laboring is in, I think she said, in some of the case law. That word still laboring, or that phrase still laboring, is in Smith. It is binding on this court. So the state may have some view that a further nuance should be developed about excited utterance doctrine, but as it is now set out by the Supreme Court, that is part of the issue. And finally, just to briefly touch on the issue of the prior convictions, and the reason I was particularly included that in the brief. Obviously, any conviction, as defense counsel said about methamphetamine, is going to be held against the defendant, particularly it shouldn't have come in because it was over the 10-year period. Drug convictions have little value in terms of credibility. And I think it's instructive that I believe the trial court's rationale was completely wrong, in the sense that what the trial judge says is, because the defendant has testified, his credibility is entirely at issue, and that makes this conviction more probative. And therefore, I'm going to say it substantially outweighs the prejudicial effect. And that's not the analysis at all, because that's always the question. If a defendant's going to testify, the credibility is issue. The analysis of probative value has to do with what the conviction itself says, rather than whether the defendant's credibility is at issue. But I am out of time, and I will ask the court to reverse this conviction. Thank you.
Thank you.